Hello students, welcome to AKS. We'll continue our discussion on fundamental rights. Let's start with Article 13 of the Constitution. So what does Article 13 of the Constitution state? It states that laws cannot be made in India that violate fundamental rights. They will be declared null and void. Those laws which violate fundamental rights will be declared null and void. Okay. Also, Article 32. Article 32 mentions right to constitutional remedies. The right to constitutional remedies. Okay. That is, whenever a person's fundamental rights are violated, such a person can go to the Supreme Court to seek for the enforcement of the fundamental rights by the writs jurisdiction. Okay. Also, outside Part 3 of the Constitution, you have Article 226. What is this Article 226? It states that whoever, when an individual's fundamental rights are violated, then that particular individual can go to the high court, any high court, okay, for the enforcement of his fundamental rights through the writ procedure, WRIT. Okay. So these are the mechanisms. These are the mechanisms which are, stating that fundamental rights are inviolable, fundamental rights are justiciable. Okay. So by stating that fundamental rights are justiciable, you know that whenever an individual's fundamental rights are violated, he can approach the judiciary. Okay. Having understood that, now let us try to move to the next topic. What is it? The next topic is the categorization of fundamental rights. As already discussed, the fundamental rights have been categorized into various categories in the Constitution itself. For example, Articles 14 to 19, okay, Article 14 to 19 are the right to equality. So like that, various categories have been mentioned in the Constitution. Before we get into the categorization of fundamental rights, let us try to understand Article 12 of the Constitution. Article 12 elaborately defines what is the state. Okay, state, because state is not supposed to make laws which violate fundamental rights. Our whole point of studying fundamental rights is it is asking the state not to make laws which violate fundamental rights. This is one of the major focus. Okay. Thus, citizens as well as the judiciary should know the agencies of the state, because the state is something through the legislative process, it is making laws, or the executive orders, it is passing executive orders. So it is a state. So there is a responsibility on the state to protect the individual's fundamental rights. And also an individual should know what are the agencies of the state, so that whenever his fundamental rights are violated, he should know by whom have they been violated and whom should he approach. So some of the agencies of the state are universities maintained out of state funds. Okay. And state includes government and the Parliament of India, legislative and executive organs, government and legislatures of the various state governments, or local authorities like panchayat, municipalities, district boards, improvement trusts, etc. All other authorities, that is statutory or non-statutory authorities like LIC, ONGC, SAIL, etc. All these agencies can be challenged in the courts because they are part of the state system. Supreme Court said that even a private body working as an instrument of the state will fall within the meaning of Article 12 of the Constitution. The only institution which is not specifically mentioned under Article 12 as part of the state system is the judiciary. Okay. But when the judiciary is functioning as an administrative and superintending body, even its actions can be challenged in terms of violation of fundamental rights. So all the major organs of the state, namely legislature, executive, as well as the judiciary, are coming under the broad meaning of the state. Okay. Next, let us try to understand what is rule of law. We have discussed about natural justice, right? Principles of natural justice. There we have mentioned that it is because of the principle of natural justice that the rule of law is upheld. So what do you mean by rule of law? Simply speaking, rule of law guarantees equality before law. So what are the various tenets of rule of law? Number one, absence of arbitrary power. Okay, that is, no man can be punished except for a breach of law. Okay. Number two, equality before law. Equality before law. What do you mean by that? That is equal subjection of all citizens to the ordinary law of the land administered by the ordinary law courts. Okay. In India, the constitution is the supreme law and it is the source of individual rights. Supreme Court said that rule of law is one of the basic feature of the constitution, and thus rule of law forms part of the basic structure of the constitution doctrine given by the Supreme Court. Okay. So what are the basic pretexts of rule of law? Absence of arbitrary power. Okay. Equality before law. So these are some of the basic pretexts of rule of law. So as we already discussed Article 12, now let us discuss Article 13, which we already have an understanding now. Article 13 states that laws which violate fundamental rights are void. That is, laws that have been made in British India and which are continued as laws in independent India, because British India never declared fundamental rights, so they come into conflict to fundamental rights. So at the time of, whenever the constitution was brought into force, whatever existing laws under Government of India Act 1935 or any other acts like Indian Independence Act, whatever laws which are violative, which are in conflict with the fundamental rights, they have been declared null and void under Article 13 of the Constitution. Number two, so whatever existing laws, the past laws, they have been declared null and void. Also, Article 13 states that from now on, okay, that is in the future date, whatever laws that are going to be made by the legislative and executive bodies of the central government or the state government, that laws cannot be made. Such laws shall not be made which are violative of the fundamental rights. Example, the Civil Procedure Code or the CRPC. These laws were made in, this is what we have discussed. The first point, we have said that whatever laws which were existent in British India, like the CRPC, Civil Procedure Code, they were existent before 26th of January 1950. So those laws have been declared null and void. But there's another provision which states that whatever future laws that are going to be made, that they should not be violative of fundamental rights. So that is about Article 13 of the Constitution. Okay. And also, the laws which are going to be made by independent India, that is independent India's parliament and legislatures of state and executive acts of states and central government, cannot make laws which are violative of fundamental rights. That is the prospective laws. Okay. And also there's another doctrine called doctrine of severability. So under this doctrine of severability, laws which violate fundamental rights will be declared null and void. So this is providing for judicial review. So there could be a law in which only a certain part is violative of fundamental right. Okay, in a law or in a bill passed by the parliament, there could be various provisions. In that, one or two provisions could be violative of fundamental rights. Other provisions can be normal. They are not in conflict with fundamental rights. So under doctrine of severability, whatever provisions which are violative, those one or two provisions which are violative of fundamental rights, only those provisions can be removed and the other law will be continuing. Okay. So under Article 13 of the Constitution, this is one of the important article because this article explicitly mentions about judicial review. This article, through these provisions, it is explicitly indicating for judicial review. That is, whenever the fundamental rights are violated, you can provide for judicial review. So Article 13 gives birth to judicial review, because the power of the courts to examine the constitutional validity of laws and executive acts and declare them as void if they are violative of fundamental rights as well as the constitution as a whole. Thus, judicial review has not been specifically mentioned in the constitution, but it has been implied. It has been implied under Article 13. That is, the implicit power given under Article 13 in the constitution is providing for judicial review to the Indian judiciary. It is not explicitly mentioned in the constitution. Please note that. Correct me. In the initial stage, I said it explicitly mentioned, but it is implicitly mentioned under Article 13. In the Kesavananda Bharati case, Supreme Court declared that judicial review is part of the basic structure of the constitution. Is part of the basic structure of the constitution, by which it means that judicial review is within the framework of India's constitution, and judicial review has been borrowed from America's constitution, which is explicitly mentioned in American constitution. All the courts in India today exercise judicial review under the declaration of Supreme Court, under the doctrine of basic structure of the constitution, in the Kesavananda Bharati case of 1973. This, as already discussed, Article 13, Article 32, and Article 226 of the Constitution is an exercise of the power of judicial review in India's constitutional scheme. Okay. Next, let us try to know about Article 14 of the Constitution. So, Article 14 of the Constitution includes two principles, namely equality before law. Equality before law. And number two is equal protection of laws. Equality before law and equal protection of laws. So, one of the principle, okay, this equality before law has been proposed by America. So it was existent in American constitutional doctrine. So what is equality before law? Equality before law, this is an English constitutional doctrine, King John issued a royal decree called Magna Carta in 1205 AD to the barons, that is aristocrats in Great Britain, stating that these aristocrats will also be subject to the laws of Great Britain. Okay, Magna Carta was confirmed by the King Edward